Hi, everyone. This is Attorney Maria Baler from the law firm of Samuel, Sayward, and Baler in Dedham, Massachusetts, where we focus our practice in the areas of estate planning, elder law, and estate and trust administration. Welcome to this week's edition of Smart Counsel for Lunch. Today, I'm going to talk with you about planning for blended families and non-married partners. Estate planning is important for everyone. And planning for traditional families where you have a husband and a wife or two spouses and children of that marriage is relatively easy. The decisions that need to be made come more easily. You know, the spouse is probably the decision maker for the other spouse in the event of incapacity. If one spouse dies, the assets likely will go to the surviving spouse, and when that spouse dies, to the couple's children. So the planning flows more easily, the decisions come more easily, and there's not as much of a barrier to planning when those decisions, are more easily made. When we have families that are not traditional because the partners are coming from previous marriages, the partners may have children from those previous marriages, or you have unmarried partners who are together, the planning is harder. There's no doubt about that. The decisions are a little less obvious and require a little more thought. The families may get along, the families may not get along. So all of those things need to be taken into account. But in these types of situations, planning is even more important. If there is, planning more important than other planning, because of the things that can happen if planning is not done properly. For example, if someone who's in a blended family dies without a will, the assets may pass in different ways depending on the situation. There may be some assets that are required by a divorce agreement to pass to the ex-spouse. There may be assets that are passing by beneficiary designation, like life insurance and retirement accounts, and maybe when the deceased spouse got divorced, they named their children as beneficiaries on those assets just because they had to change the beneficiary designation from the ex-spouse to someone. And often those designations are done in a hurry and the children were put on there. But what if those children are still minors? Or what if they're too young to really handle appropriately the amount of assets they're going to inherit through those beneficiary designations? That can be an issue. If a deceased person dies without a will in a blended family, the statutes of the Commonwealth of Massachusetts will dictate how their assets are distributed. If they have more than $100,000, then the law says the surviving spouse gets the first $100,000, but everything else will be divided between the surviving spouse and the children of the deceased spouse who are not the surviving spouse's children, or other heirs of the deceased spouse. Because the law recognizes that if the deceased person had children from a prior marriage, or if the surviving spouse has children from a prior marriage, it probably doesn't make sense, or the deceased probably wouldn't have wanted everything to go to the surviving spouse because the surviving spouse's will dictate where those assets go. And when the surviving spouse dies, it's likely those assets may go to the surviving spouse's children, not to the children of the deceased spouse. So the law takes that into account and would instead leave assets directly to the children of the deceased spouse in that circumstance. So all of this is to say the law has its own ideas about how assets should be distributed at death, but those may not be your ideas. So that's why planning is so important. In the event of incapacity, we also plan to make sure that people can make decisions for you if you're not able to make them for yourself with respect to healthcare and financial matters. In a blended family, having documents that name those decision makers, like a power of attorney and a healthcare proxy, can be even more important. If those documents are not in place, there could be disagreements between the surviving spouse and the adult children of the incapacitated person in terms of who is to make decisions. And if there are no documents in place, a guardianship or a conservatorship might be required, and the court is going to have to decide between these competing parties who the right person is to make those kinds of decisions. In an unmarried situation, the partner who is not incapacitated really has no legal standing to make any decisions on behalf of the incapacitated person, or even to receive information about the incapacitated person's medical situation or finances, unless there are legal documents in place that give them that authority. So you can see how those documents really are an important thing to get into place. Not to say where assets go at death, but to allow decision-making and information sharing if one partner or one member of the couple were to become ill. Also impacting, any legal documents we might do for people in these situations are agreements they may have made in the past. Oftentimes, as I mentioned, divorce agreements from a first marriage might have certain requirements in them about life insurance or retirement account beneficiaries or payment for children's education that continue in effect, and that might impact the estate plan we do for this second marriage. There might be prenuptial agreements that someone has entered into in a second marriage situation where they're trying to protect assets in the event of a divorce, or even in the event of death, dictating where assets will go. So all of those agreements have to be taken into account when we're planning for people in a second marriage type situation. Although there's never a reason not to do planning, I would say. If you're a member of a blended family or an unmarried couple, I would argue planning is even more important because all of these unexpected situations that can arise where you want to have a clear vision for what makes sense. You want to be able to choose your decision makers. You want your assets to be distributed in a coordinated way, in a thoughtful way, to your spouse, to your partner, to your children from a prior marriage, perhaps in a particular order, perhaps divided thoughtfully with a certain percentage going to each group of people, so that perhaps children from a prior marriage don't have to wait until the second spouse passes to inherit assets, but don't receive so many assets that the surviving spouse is not able to take care of himself or herself. So all of these are things we take into account when planning for people in these situations, and we're happy to walk you through the different considerations, talk things through with you, and help you make informed and thoughtful decisions and get some good estate plan documents in place so that your family will have the tools they need, the access and the authority they need, and will be clear about what your instructions are, which will hopefully preserve relationships after you pass away and have everything run smoothly in the way you wanted it to. So thank you for listening. We look forward to helping you think through these things. If we can be of assistance, please be in touch. And if you like this video, give it a thumbs up. If you'd like to follow our YouTube channel, please go ahead and do that so you'll be notified if or as additional videos are posted, which we try and do at least once a week. Thanks, everybody. Take care. Have a good night.